Welcome everyone. This is the July 2023 Ibis Prep MBE crash course, and we're super excited. We have a lot of people in the room, and we just did an MBE contracts Jeopardy review. I think it went pretty well, but I also spent a lot of time explaining things. For instance, the final Jeopardy question was talking about a no assignment clause, and a no assignment clause will ban assignment and delegation of the contract. Assignment of the rights, delegation of the duties. Whereas a no delegation clause will only ban the delegation, but it's still freely assignable. And I know that's an interesting way to start the recording, but the point of that is because contracts on the MBE is a very detail-oriented subject. You really have to know a lot of different fact patterns in order to excel, and that's one of the fact patterns. Another fact pattern we might see, and this is something we just talked about in Jeopardy, is the intended beneficiary fact pattern, right? There's one question where there's a agreement between a hospital and a cleaning company that they have to keep the rooms of a certain quality of cleanliness, right? And they fail to do that. And then a patient gets sick in the hospital room. Is that patient an intended or an incidental beneficiary? The answer there is incidental, right? Because it's too far removed. They weren't named in the contract. There was no reason to think that they could objectively claim under the contract. Another fact pattern is we have two brothers, Tommy and Johnny, and they agree to pay their mother $100 a month in support, and they do it for a couple months. And then 1 month, Tommy stops paying. Well, now the mother, she was an intended beneficiary. The contract was intended to benefit her. She had already relied on the contract. She went off and bought, new jewelry, and her rights had vested. And that's the difference between an intended beneficiary and an incidental beneficiary. And I really believe when it comes to the MBE, the key to this all is fact pattern recognition. And as I'll explain, the way to start recognizing these patterns is to do practice question, practice question, practice question. So right now I'm going to share my drive, and we'll be able to talk about how I believe everyone can succeed on the MBE moving forward. The MBE for me is a lot easier for me to teach than an essay subject or any other state subject, because if you think about it, it's 7 subjects and we have about 10 weeks. So each week we can do one subject, and you'll see on my calendar, this week we're going to do contracts, next week torts, then con law, then property, then civ pro, then evidence, then crim law and crim pro, which are combined. And then we have review, right? A lot of time for review. Whereas my state course goes right up to the wire. So this course is more manageable, where each week we should really focus on mastering a particular subject. And this week it's contracts. And when it comes to the MBE, there's nothing better that you could do than interactive practice questions. And when you're doing interactive practice questions, you don't want to just do them and get the answer and move forward. What you really want to do is document and review. So let's say you're doing 25 questions, which is the minimum. I recommend 25 questions per day, 50 on a good day, and 100 on a really great day. This calendar is just kind of a minimum. If you could do 25 questions a day, that's a good, healthy, balanced diet. But typically you should try to reach for more questions. A good measuring stick for yourself is 2,000 questions minimum. If you don't do 2,000 questions, you're very unlikely to pass the test. 4,000 questions ideally. And of course, if you do 4,000 questions and you have an interactive Q bank that only has, let's say, 1,800 questions, you're going to repeat questions. That's fine, because the repetition is the best thing that you can do. It's all about pattern recognition. I want you to do these questions over and over and over until you've memorized the patterns as well as I can. And then there's a saying that I learned from one of my students, Sam Collier, who passed on her 5th attempt while working full-time, raising 5 kids. And she told me, same clown, different wig. And that's what I've come to realize the MBE is. The same kid who was ice skating on the pond that was, the ice hadn't frozen, is the same dumb kid who's, in the grocery store doing something negligent. You just memorize the fact pattern and you'll say, okay, we're going to hold him to this duty of care because he's a kid. So we're going to do tons of questions and we're going to do them on my workshops every Sunday. Hopefully you can make it. I know there's religious obligations, but hopefully you can lock in and make it from 11 to 1. And we're just going to do live interactive questions. try to answer them as a group and go over them. So that's how the calendar works, and you should all be able to access that and enjoy it. If you go to the MBE Crash Course folder, there's weekly assignments. Week 1 assignments, I know a lot of us just graduated and you celebrated, but now it's time to start working. So review all PowerPoints, outlines, and cram guides in the drive. And we're really going to spend a lot of time going over them on Thursday, but that's something you could do on your own, just dissect my drive. I know a lot of you are in commercial courses too, dissect their material. I don't believe in, just use one brand, wear Adidas one day and Nike the other day, but I do believe that my brand is, the luxury bespoke brand that we really have the most refined materials that you could focus on. So I want you to review our PowerPoints, outlines, and cram guides. The cram guides in the drive are literally what I'm asking you to do yourselves. When I first started studying for my first MBE I ever took in 2017, this is what I did. I created guides of questions that I either got wrong or didn't feel comfortable with, and I teased out the rule of law. The lesson that I should learn from that question, or the fact pattern that I should learn that'll be useful. So then I put them on the drive for you all. So you can just go over my cram guides and I'll show you them. They're really good to go over. Again, get addicted to doing questions. If you can't sleep at night, get your phone out on a mobile app. If you want to talk to me about which interactive Q banks I recommend, we have questions on our drive too, but just be doing questions. And like I said, document the learn rule of law from all missed or uncomfortable questions. Does anyone have any questions about that process? I know with my students, we literally do that in sessions together, and we'll do it on Sunday. If we get any questions wrong, we will get a few wrong. If we get any questions wrong, we'll have a running sheet that will have this exact process so you can see how to replicate it. Okay, this is another thing. Complete and submit the MBE contracts questionnaire, and complete and review the contracts Q&A. These are 2 new things that I've added to my MBE drive this time. We're always getting better. So I have an instructor of mine, Matt Beckerman, who scored a 167 on the MBE. For those of you who don't know what that means, that's because it's such a ridiculously high score. And he's brilliant. First thing I did when I hired him was say, hey, I want you to create materials that replicate what you did so that my students can feel comfortable. And we're going to go over them, on Thursday. We'll do as much as we can, but also on your own, I want you to complete and submit those questionnaires, which if you're in my Florida course, these ones are much more detailed, right? Instead of being 30 questions, there may be like 60 questions because the MBE does go into the details more. PD and I already did this questionnaire and we have the answer. So you could cheat, but we just did it quick. I'd like you to take the time to do the learning process of understanding how to answer these questions, and that'll be very thorough. And then we create our own questions and answers, which are not that similar to MBE questions. I want you all to have an official MBE Q bank, but they're just good questions, like 50 questions to just reinforce some of the fundamentals of MBE contracts law. And then submit an MBE progress report on Monday. So if you go on your drive, there's accountability folders, right? Every one of you should have your own folder. And Jesse was working this morning on making sure that, only the student and the staff has access to your individual folder, but cut us a break because you don't have anything in there yet. So we'll figure it out this week. So that is the case. And just like in my essay course, I want you to submit your essays. In this course, I would like you to submit your accountability, meaning a report of how many questions you've done that week and how you're doing by subject. There's some major companies that have these adaptive Q banks available, and they all have progress reports. So like, if you can't do that and you still have like a book of questions, we'll figure out a way for you, get in contact with us. But ideally, I want to see your progress reports. I am, sorry, I'm raising the bar, right? I'm raising the bar on what I need for my students, because last administration, the MBE had a 25% passage rate. I had one student who I worked with super hard, and I thought she was literally going to work for me. That's how amazing she was going to do. And she passed, by the skin of her teeth. And I was surprised. And then, I had some other students who scored very high, but just not as high as I thought they were going to score. And just, it kind of hit me like, okay, we have to work a little bit harder and prepare ourselves a little bit more. We're not shooting for a 136, we're shooting for 150s, right? And I'm telling you, what it takes to get 150s is a lot of a lot of consistency and regimentation and self-accountability of doing practice questions. We're in the month of May. So you're going to get crushed on these practice questions. I'm just being honest. You're going to get maybe 50%, 60%, whatever it may be. That's fine. Month of June, let's do better. By the month of July, you should really be aiming to be scoring above 75% in every single subject, ideally 80%. If you can be scoring in the 80% on every single one of those 7 subjects, you're going to pass with flying colors. If you're scoring 75% or higher, you should be in good position to pass. If you're scoring 70 or higher, yeah, that's passing. 65 to 75, now you're cutting it extra close. Below 65, you know you need a really great performance. And why do I say that? Because you're more likely to do better on practice day than test day. Because on practice day, it's more chill. You have questions that you've literally seen before. I'm sorry, just admit it. You've seen the question before. That's why you know it's C. So like your score is going to be a little bit better. There's no purpose in lying to yourself. If you know you need in your state a 62% average, and that's like a 136 to pass, well, then I wouldn't be comfortable if I'm only scoring 64% on my practice questions. I'd really like to see 75, 80. So let's get to work on practice questions. 2,000 minimum, 4,000 is the ideal number. And if it makes you feel better, I'm taking the UBE in July and I'm taking tons of practice questions. I'm going to hit 4,000 easily. So we're all here. It's not going to be fun. We're just going to commit to hard work. Does anyone have any questions about, the approach for assignments? A big emphasis is practice questions, as you can see, and that's for a reason, because a lot of the other companies will have you drowning in the outlines and not jumping into the practice questions. I'm a much bigger believer that you need to have experience with practice questions. But of course, we do have outlines, and I think our outlines are distilled nicely for you. They're not 1,000 pages. They're more like digestible. It's a weird word, but best I can do. So if we look at the materials folder, we have a strong outline. I would definitely go over this outline from head to toe and make sure you know it well. The PowerPoint, I'm going to go over right now for just a little bit. Like I said, the Cram guide is literally what I want you to do on your own. I want you to all create your own Cram guides. For instance, unilateral contracts can be accepted by performance. If a school offers a reward for a writing competition and someone writes the essay, they have accepted the offer and it cannot be rescinded, right? That is a unilateral contract as opposed to a bilateral contract. Now I always know, oh, the puppy picture, unilateral contract, got it. Physical incapacity of a person necessary to perform of a contract discharges the duty to perform, just like death, right? It's a very sad thing that's going to discharge a duty. Do you see how right here, delegation is duties, not rights, novation, substitution of the parties. I wrote these Cram guides in a way that are just right to the point. And 10 pages is not it's not for nothing. It's substantial, and this is a very hard test. And I hope everyone understands, by the fact that there's repeat test takers in the room and they had a 25% overall passage rate, that this test isn't designed to be easy. It's extremely difficult, and we need to absorb the details. And I've provided you with so many details, but there's different strokes for different folks. People learn differently, and you got to figure out what is going to resonate with you and then apply it to practice questions and make sure that eventually by the month of July, you're scoring a high percentage. So the Cram guides, I'm a huge proponent of. I think you guys should like them. The questionnaires, like I said, this was made by Matt Beckerman, who, Jimmy Neutron. So I don't know if people even know who that kid is anymore. That's a dated reference. But yeah, 54 questions, right? This is great. Fill these out. Like I said, Pete and I did it. I even put our answers in the chat or in this folder, but you can see, they're just very quick. I would like you to do it more detailed and really master that. This is the Q bank and the answers that we made. Again, they're not like that similar to MBE questions, but they are for the purpose of reinforcing fundamentals. And then this is from February 2023. Usually we crushed it. I think we got 33 out of 35. I'm a little embarrassed, but it's the answers and explanations from the ones we did last time. And look, if you read all over them and you get the explanations, then that'll give you a leg up when we do them live. Even if you just memorize it, I'm okay with that. Because at the end of the day, memorization is a very close cousin to learning. right? And so if you're just memorizing, at least you're memorizing correct things. So I think that's a good way to look at it. And then the Jeopardy game we played this morning before the recording, you can access here. So those are the materials. That's the materials folder. We have the assignments folder, accountability folder, materials folder, and then this video itself, live being recorded, will be added very soon, as soon as my guy puts an intro on it. So we're here to help. I think the accountability folders, if your folder is filled up and you have 4,000 questions and you're doing great, you're gonna pass. If not, there's still a chance. There's always a chance. I treat all of you like you're boxers going into the gym and it's training, and I'm going to get you all in the best condition and put you in the best position to rock and roll. Whatever it takes, my team, we're here for you. So let's just spend a little bit of time today going over the PowerPoint. Like I said, I'm going to go like 10 or 15 minutes over the 8 p.m. time because we did the intros. Usually I'll end like, 5 or 8 minutes afterwards just to make sure I'm diligent about things, but I am respectful of your time and I'm going to do my best today. If you feel like I flew through material today or I went too fast or you didn't learn anything, just know we're circling back to everything on Thursday, brick by brick, and then on Sunday, we'll put it all together. In the meantime, on your own, if you don't know what to do, you're freaking out, just start doing practice questions. I really believe that. Okay, so if we go into the materials folder, there's 2 things we could do. I think next class we'll look at the outline. This class, let's look at the PowerPoint because there's also some I don't know, just general advice on here. So this is me and my father, my grandfather. We all went to UM Law. I know there's some UM Law graduates in the room. I have a comprehensive business where we don't just teach for the bar. We teach for California bar, Series 7, 66, LSAT, GMAT, all subjects under the sun. I have over 50 instructors on my staff, but this is my baby here, the Florida bar. I believe in education reform because not enough people are passing these tests. So something's got to be wrong. We're just trying to help people. Mindfulness, is important to me. I think that the test is so difficult and it's such a lonely experience studying for it that you need to have practices in place to, really feel good about yourself, because if you're in a good place, then you're going to be in a good place to learn. Ibis Prep support line, we have that Telegram chat. It has all my instructors are in there. I'm in there. Jesse, James, Alexis, we're all in there. And a lot of your friends now are in there. So be active. That's a safe place for us to support each other. It's all good vibes here. Just some MBE statistics. It's a 200 question test, right? Unless you have some sort of accommodations, but just know that you got to focus on time. At some point, a lot of people run out of time, and that's not good. And we need to replicate testing under time circumstances to make sure that doesn't happen. So study strategy, I was talking to you about Sam. Sam is amazing. She believes in us, and she'll tell you to work hard, and we'll tell you the same thing. Spend the majority of your time simulating the test and learning from the results and doing at least 25 questions. I can't stress that enough. This was from one of my old instructors, my former instructors, and some points that she had, and you guys could go over this on your own, but focus on learning the law. Knowing why you got it right is almost, if not as important than why you got it wrong. Exactly. Learning pad review method, I talked about that. Write it down. Stay away from absolute answers. This is a key point. Thank you, Letty. Stay away from absolute answers. Never, always, rarely, or very unlikely. The law would always do anything. We are masters of it depends. That's a good pointer. Stick to the facts of the question. Don't say I need to know more. You don't. Focus on what you have and what the facts can do for you. I love the MBE. I know it sounds weird, but I love doing MBE questions. All day long, I tutor students and we just do MBE questions together, and my day is chilling. Because it's fun to me, because the right answer is on the page. There's 4 answers, one of them's right. It's like playing a game. You just got to pick the right answer. You don't have to be creative. You just have to pick the right answer. A lot of times you're going to narrow it down to 2, and that's where it gets tricky, but we're going to get better at this. Okay, read carefully, process of elimination. Each question is an island. There's one correct answer, and it's the answer that directly resolves the problem. We like that. Contracts is formation of contracts, performance, breach, and discharge. Defenses to enforceability. contract content and meaning, remedies, and third-party rights. So a lot of it is formation of contracts, offer, acceptance, consideration. And then a lot of it is performance, breach, and discharge. And contracts, like I said, I can't sugarcoat it, very difficult subject. We're gonna go over a lot of details next class. Basics, we talked about unilateral versus bilateral contract, bilateral contract formation, offer, acceptor, consideration, where unilateral is accepted by performance. If you show up and with the dog poster, that's a unilateral contract. Goods are the UCC. Common law is land and services. Make sure you understand that distinction. I talked about earlier mirror image rule test. If it's common law, the terms of the offer must match the terms of the acceptance exactly, or else it's a counteroffer. Under the UCC, we use the ballot of forms provision, where an additional term, so long as it does not materially alter the contract, it will be included in the contract. Now, we'll look over some of those questions closely. Special rules that apply to merchants, such as no consideration needed for a modification. Also, no consideration needed for the options contract, the firm offer. Look at the facts of the question. If they say Andrew, an experienced instructor, Andrew, an experienced tomato salesman, he's probably a merchant, and that'll be important. A lot of the questions I could do very quickly because I just connect the dots. I'm like merchant, offer, firm offer, they don't need consideration, the answer is B. You know what I mean? I want to turn you guys into those types of machines. Okay. If I'm moving fast again today, remember, we're going to go back over everything. Offer, meaning of the minds, mutual assent. There's intent to be bound by the terms. Just make sure I am thinking about doing, I'm offering to do this. I accept to do this. Consideration, you have to be legally obligated to do something. If I said to someone like, I'll teach this class if you give me $50, I already had to teach this class. That's not new consideration, right? You have to have a new legal obligation to do something. This one, we talked about the notice of accommodation and the shipment of non-conforming goods, where you ask for someone to deliver prompt shipment. They ship something a little bit different. That's not a counter offer. That's an acceptance and a breach. Unless it comes with the notice of accommodation, then it's a counter offer. All right. Sorry. So breach, when the one party doesn't do what they're supposed to do. Look for the breach. That's the claim of action. There's a lot of defenses to contracts. Statute of frauds. Make sure that you notice, first and foremost, identify the parties, right? Who are the parties to the contract? Are they merchants? And is there any importance? And then have your radar on for, was it a phone call or was it written? And that will implicate the statute of frauds, because we know my legs, contracts for marriage, contracts that cannot be completed within 1 year, contracts for land, executorships, goods over $500, and suretyships all need to be in writing to conform with the statute of frauds. That's a major defense. So when you're going through these questions, you say, okay, was there a contract? Great. But was there some defense we could apply? Like we talked about early, incapacity, the person was too young or too drunk. We talked about duress, they were threatened, or misrepresentation, like I pretended like I was this person, but I was that person, whatever it may be. Mistake is a big one. Mistake is a huge one. Mutual versus unilateral mistake. I'm gonna meditate on this for a second. Unilateral mistake is if Johnny and Tommy have a contract and Johnny thinks it's for this type of horse, but it's obviously that type of horse, and Tommy knows it's that type of horse, and the contract goes on. The person who was mistaken is going to have to bear the risk of that mistake. You should have read the contract. Like the show must go on. We're not going to excuse a party for a unilateral mistake unless the non-mistaken party in bad faith knew of the other party's mistake and essentially took advantage of them. Like Johnny knew that Tommy thought it was that horse, but it should have thought it was this horse, right? That's a way that a unilateral mistake will make a contract rescindable. A mutual mistake, we're always rescinding the contract. Why? Because there was no meeting of the minds. If Tommy and Johnny are totally like mistaken about, what they're talking about, we can rescind the contract. So make sure we're pretty, we are confident in mistake, unilateral versus mutual, and then very confident in statute of frauds. One thing, impossibility versus impracticality, right? Impossibility means there's no way that it can be performed. Impracticality means it will be really difficult to perform, but it still might be able to. we'll talk about more of these things again. This is just a general, like, get the wheels turning, first day of contract law. You can see I'm not that scary. We're going to have some fun in this class. Damages, just in general, damages are either legal or equitable. Legal relief is monetary relief. Legal relief is going to put the party in the position they would have been if the contract had been performed. That's specifically expectation damages. But when we think of legal relief, we're thinking of money. What are we going to pay the person who didn't do anything wrong? We could have expectation damages, like I said, what do they expect? And that's the best form of measurement. When you are taking the test and you are so scared by a mathematics question on contracts, just take a step back and be like, okay, who didn't do anything wrong here? Oh, Tommy. Tommy did nothing wrong. What did Tommy expect? Tommy expected to pay $1,000 for this service. Well, Tommy paid $600 for this service. Then he had to go and pay $600 more to get the, mitigation, the other person do it. He paid $1,200 for the service. He's entitled to $200, right? Because he expected it to be $1,000. He had to pay $200. Don't get carried away by the other facts of what Johnny, he had to pay for this and all of that. Who cares? He's not the one. He's the one who breached. We're here to protect the non-breaching party and put them in the position they would have been. Equitable relief is going to occur when monetary damages wouldn't be sufficient, like real property. We want them to have that actual house or a piece of art, a Van Gogh painting. Like you bargain for that specific painting and we're going to specifically perform that, or we're going to force that party to perform. There's other different types of relief, like legal relief includes expectation, consequential. Consequential, the key word is foreseeable. Peanut butter and jelly, those words in your mind, consequential and foreseeable. Incidental damages are, the breach occurs and now you got to drive to Toledo and the drive takes 3 hours in gas. Reliance damages for relying on the contract. Restitution to disgorge ill-gotten gains, lost profits, lost wages. Equitable relief includes specific performance. Injunctive relief. So injunctive relief we'll talk about more in Civ Pro, but it could either be like a preliminary injunction or a TRO, a temporary restraining order, but that's the type of equitable relief. Rescission, tearing up the contract. Reformation, reforming the contract to make it equitable. Quasi-contract, a fictitious contract to enforce, to prevent unjust enrichment or ill-gotten gains. And then promissory estoppel. We'll see promissory estoppel where it's like, it would be unjust not to force the party to perform. Okay. Common issues on the MBE, installment contracts. I think we've talked about a decent amount today, where you're paying an installment, but if you don't deliver one of the installments, you will have the opportunity to cure on a subsequent installment. Liquidated damages, used to contemplate damages ahead of time when they would be too difficult, and speculative to measure in the event of a breach. We talked about construction contracts. They must be reasonable. You can't say, well, if Andrew doesn't lay down the foundation, then he's liable for 90% of the contract price. Like, no, that's too much. Third-party beneficiaries, TPBs. I started the recording off by explaining 2 scenarios of TPBs, and make sure you work on these types of scenarios. They're tough. Anticipatory repudiation, as I spoke about, unequivocal. And if you're listening to the recording and you're like, he never spoke about that, I mean during the Jeopardy game. But anticipatory repudiation means unequivocal. If I say, I'm not going to honor my contract unless I'm legally obligated to, that is not unequivocal, because you are legally obligated to. It has to be, I am not doing what I'm supposed to do. Then you could either sue because they breached or wait until the breach occurs. And remember, the merchants have the request for further assurances, which is a 30-day written rule. And then parole evidence. I said on the MBE, parole evidence is coming in. There's evidence that Andrew and Tommy talked about a condition. Well, we're not bringing in oral evidence to contradict. No, that's not contradicting the contract. That's showing a condition, or that's clarifying ambiguous term, And I thought tutoring meant like, just like not doing much, but you thought tutoring meant doing all this. And now we're going to bring in evidence from Google about what tutoring means, right? That'd be clarifying ambiguous term, or to show it was fraud or duress or some defect information. Like I said, when you're in doubt on the MBE, we're going to try and bring the parole evidence in. Okay, so the last few slides here are literally it's a lot of them, but these slides, I was like, how could I help students who are just looking at this PowerPoint? And the way that I thought was best was just taking points from my cram guide. So this is actually, we're not quite there, but towards the end right here where it says detailed explanations and more details, these are literally just points from my cram guide. Like the remedy for conversion is the fair market value at goods at the time of conversion. Conversion is a tort. A seller can treat a buyer's failure to specify as a breach only if the buyer's failure to specify materially impacts the seller's performance. Again, so at the end of this PowerPoint, you can all look over, but again, these are straight from the cram guide. So you don't need to like necessarily review that twice. How to measure damages, like I said, the best way to measure damages is the general expectation formula, what you expected, plus the loss in value and other loss, plus minus any cost avoided and loss avoided. So a simple way of thinking about that is like the person who was not in breach, what did they expect? What other costs did they have to, incur? And then should they have mitigated? And we're going to subtract any, duty of mitigation from them. And then TPBs, I'll just read this one. A third party acquires standing to enforce a promise only if that party is an intended beneficiary of the promise. The promisor and promisee retain the power to modify or discharge the duty owed to an intended beneficiary until the beneficiary's rights vest. The beneficiary's rights will vest if he manifests assent to or materially changes his or her position, in justifiable reliance on the promise before receiving notice of the discharge. So again, that process of TPB, intended beneficiary, is interesting because it's not important just that you are intended, but your rights have to actually vest before you can stand in the shoes and enforce the contract. And when will an intended beneficiary's rights vest? When they manifest assent or materially change their position in justifiable reliance. So that's, as much as I want to go over of the PowerPoint today. Just in general, before I, wrap things up, does anyone have any questions or specific pointers or things on their mind related to MBE contracts that they had for me?
I do. This is Chelsea. Earlier when we were doing the Jeopardy game, I think you did kind of state something about it, and I think maybe someone did kind of state it, but the quasi contract, was that the term you were, I forgot what was the Jeopardy question verbatim, was that the term you were saying could be synonymous to when, I just can't remember everything verbatim, but yeah.
Yeah, it's similar to restitution.
Yeah.
The quasi contract concept is a fictitious contract where we don't have a contract here. The kid was a minor or whatever, for whatever reason, there's no contract. This is not a valid contract, but we're like, we have to enforce this or it would be totally unjust. That's kind of the same idea of restitution because it's to disgorge ill-gotten gains. These are measures that the court can take to make things right. And that's why I like contracts. You'll see next week, I love torts. That's my favorite subject. But contracts I tend to like overall because there's logic to it, right? We're all in a world where we deal with contracts all the time, and contracts have to operate under the premise of good faith. So if one person is a bad actor, if they misrepresented or they did something wrong, then they're probably going to be at fault. I was doing some contracts questions before this course just to get my wheels turning. And just one thing that I saw come up twice, so I thought I might end class by speaking on this, was the scenario where there is a condition where there's a seller and a buyer, and the buyer needs to seek financing, right? Has anyone ever encountered this type of question? I see some people shaking their heads, yeah. So there's a seller and the buyer needs to seek financing. It's like, hey, I'm gonna buy this house, but the buyer's like, but only if I can get financing at 10%, right? Now, the buyer is not able to get financing at 10%. He can only get 11%, but he's like, you know what? I'm gonna go through with it anyway. The seller sees that he can sell the house for more. Can the seller get out of the contract because that condition was not met, because the buyer couldn't meet that condition? Yeah, EJ, I see you shaking your head no. And next you said you did the exact same question earlier. Yeah, it's pattern recognition. The reason why the answer is no is because that was a condition for the buyer. The seller can't be like, oh, well, this condition wasn't met, so I'm getting out of the contract. No, think about who the condition was meant to protect, and that's who could take shelter in it. A similar question arises when, hey, we're gonna do this deal, you gotta get financing, if you can get approved for financing. And then the buyer just sits on his couch and doesn't take any steps to get financing. Has he breached? We're saying, yes, he breached. Why? Because inherently, in good faith, if there's a condition like that where the buyer is supposed to seek financing, you do have to take reasonable efforts to seek financing. That's your duty under the contract. So we'll see next class. I'm going to go deep into the outlines. I'm going to, cover everything again. Like, I don't want anyone to feel this went all over your head. The point of today was just like, class has begun, right? This is bar prep. We're starting, and you had your fun, but now let's really lock in. And this week, let's focus on mastering contracts.